So when I look at equity compensation, I think it's probably the biggest tax issue for most recently formed or startup companies, because equity is something everyone has to figure out early on, and it's very tax sensitive. So most startup companies don't really have, they're developing something clearly, and they'll probably have to file a tax return at some point, but they might not have a lot of income. They probably don't have a lot of transactions going on other than equity. So there's not really a lot of other tax issues that we have to be careful of. But when you're talking about equity, you really do have to be careful, and it really is a significant issue. So here's a quick overview slide. We're going to cover these different topics: restricted stock, RSUs, phantom and incentive plans, stock options, both NSOs and ISOs, some revenue sharing, and profits interest. I'll stand over here, actually. So restricted stock, just quickly what it is stock that is subject to vesting. And what I mean by vesting is the service provider typically has to continue to provide services to keep the stock. They have the stock now, but if they leave the company can typically take it back. Not at the current value of the stock at that future time, but for whatever that service provider might have paid for the stock, or if they didn't pay anything for the stock, then they just have to give it back. So that's what I mean by restricted or subject to vesting. A lot of people say, well, restricted stock means stock that's not transferable. Almost no stock anyone gets these days is transferable, except for publicly traded stock. So it's not just that, it's really the obligation to give it back if you leave the company. And that obligation typically goes away, so that's the way it vests. So over time, the company's right to take back that stock will go away, so you're essentially vesting, and typically that occurs over 4 years. So it's real equity, but you might have to give it back if you leave. And the taxation of this depends in large part of whether or not you make a tax election called an 83B election. So if you receive restricted stock, and let's just say there's no Section 83 election, then you're taxed on the value of that stock as compensation income on the dates that it vests and the value at the time that it vests. So if you get stock now, and let's say it's a very early stage company and it's not worth a whole lot, but you didn't file the 83B election and you're vesting over 4 years, when you get to that 4th year and you're vesting, it could be worth a whole lot. So and all of a sudden you have a lot of compensation income. So that's why there's this alternative where people file what's called an 83B election. And what that does is, for tax purposes, treat the stock as though it were vested at the date of grant. You have to file this election within 30 days of receiving the restricted stock. And again, so you're deciding that I want to pay taxes on the value of the stock now at the time of grant, not as it vests over time and at those future values. So it's frequently used, and the 83B election is frequently made when the stock is of little or no value. And then after that point of determining whether the grant itself is taxed or whether the vesting dates are taxed, then they have shares. And the next tax event likely would be some sort of dividend, although that rarely happens. It's probably a sale of the company. And at that point, if they've made the 83B election, or they've held the stock for at least a year after vesting, or a year from the grant, if they made the 83B, then they could potentially get long-term capital gain. So hopefully they made an 83B election with little value to report on the return, and then held the stock for more than a year, and then they sell it, and hopefully for a lot of money, and they get capital gain. So that's sort of the game that you're playing. And I would say that it's used, like I said just now, for companies that have low value stock. And if you're making significant grants, because a company that's making sort of a lot of grants to a lot of people, I think it would be more traditional to use an option plan, because it's just not such a big tax issue for each grantee. They're receiving such a small percentage of the company. But if you're making any sizable grant to a person, to a service provider, and you want it to be subject to vesting, and the stock is of relatively little value, then you'd probably use restricted stock and have them make the 83B election. If the stock is more significant in value, it could kind of be a tax disaster, though, right? Because they're getting stock that either they're paying taxes now by filing the 83B, or they're paying taxes when it vests. If it's really valuable, they're reporting a lot of income, paying taxes, but they don't have cash. You're not giving them cash. You're giving them stock that they can't trade. So it wouldn't typically be used with higher value stock. Although there's one potential fix to that, and that is when you have them pay for the stock. If someone's paying for the stock, then they don't have any income to report when they file that 83B because they're paying the value. And people say, well, I don't want to pay $50,000 for this private company stock, even though it might be worth that right now. So what you more often see in this hypothetical is that they would pay with a promissory note. So that just essentially means they would owe the money to the company, and they're paying for that stock, but they're issuing the company a note that the company would call at some future time. The notes typically, they have to have a maturity date because otherwise it's probably not actual debt. And they're typically also repayable on the earlier of a sale of the company or their termination of the services. So there's some scenarios out there where something bad could happen, and they might end up having to repay this debt to the company. So there's some risk certainly involved in that alternative, but it's still chosen because I think because people can receive the equity now, start long-term capital gain holding period, not pay taxes yet because they're essentially paying for the stock with the note, and preserve that potential for capital gain in the future. And even though and you would do it because again the stock's worth something now, and you don't want to just pay that amount, and you don't want to pay taxes on that amount. So it kind of puts that issue off. And the company might forgive the note at some point in time, but we don't typically write that in the documents, although we might have different opinions about that. And then you would expect it just to be repaid when they sold the company at a gain. So if everything goes as planned, they make a ton of money and they repay the debt to the company at the same time, and they get long-term capital gain. So it's a good structure in certain cases. And keep in mind that 83B election, it's not something you can get an extension for. You need to file it within 30 days. It's an actual filing that you make to the IRS. There's recent regulations that say you don't have to attach it to your tax return the next year anymore. I mean, people didn't really do that anyway, I don't think, because there was a case that said you didn't really have to. But now that the law's kind of caught up, and you don't have to attach it to the tax return the next year, I think.
John?
Yeah.
Quick question. For the note,
Mm-hmm.
For the restricted stock, does that affect qualified small business stock eligibility?
It's a good question. Let me think. You're paying for it with the note. I don't believe it should.
Cash or maybe
Yeah,
property.
Yeah, I mean, even if you hadn't, like, let's say you had paid in services, you just received stock. I mean, you paid taxes on it. I mean, I'm pretty sure that would still be qualified small business stock too. So I don't think it should affect it. Oh yeah, one other thing I should mention about the note is that it should be recourse, because otherwise there's some tax rules out there in the Treasury regulations that say that if this note of the service provider doesn't have any downside risk, then they're essentially holding the equivalent of a stock option for tax purposes. So you don't really get the benefits of capital gain potentially if you don't have recourse on the note. But that's a good question. And QSBS stock, I mean, it's a good thing to always, like, you do your tax analysis and then ask the question, is this a problem for QSBS purposes or not? And it's almost always another layer on top of every question that you should run through. So it's a good question to always ask. Okay, I don't think there's that much useful on this slide. So now I'm going to turn to the next topic of restricted stock units, or RSUs. And this can mean a lot of different things, and you hear clients say RSUs, but I think that the truth is you don't know what they mean until you look at the documents that are involved, because different people mean different things when they say RSUs. And sometimes they mean restricted stock, which is what I just talked about. They actually mean restricted stock. They just said RSUs for some reason. Sometimes they mean equity in an LLC that has units or something like that. But what I think is the most common meaning for RSUs is what's listed up here, which is basically an agreement to issue stock of the company on these future vesting dates. So if Facebook did this, for example, before they were going IPO. It said essentially, you have this many RSUs. That means that 6 months after the IPO, we'll give you this many shares of stock, assuming you're still with the company at that time. And so basically, for tax purposes, you're just getting a bonus paid in stock, and you're taxed at ordinary income rates on that bonus. You don't have any property yet, so you can't make an 83B election. It's just not applicable. It's just a future bonus on the vesting dates. And I put on here that it's not typically used for private companies because, if that stock is valuable, now you've got taxable income and you've got no cash. So it's just not a good result for tax purposes in most cases. And public companies started using it, I think, because of market volatility. They used stock options for a very long time. But I think employees and the companies started to realize, well, I just granted stock options at the fair market value, but the market's controlling this, and it's going down all of a sudden. All these options that everyone has are worthless, and it's not really incentivizing anyone. They could go through some procedures to lower the option price to fair market value if it has gone down, but it's sort of a task to do that, and you don't want to have to do that every couple of years. So people started doing RSUs for publicly traded companies because they know that the employee will at least receive something, and the value does depend on the market, but you don't have to sort of go through this chore of determining the fair market value and then potentially lowering the option price for people who are no longer in the money. So it's a good tool for publicly traded companies, but I don't think it's such a tool for private companies. The next one is a more commonly tool for private companies, and it's called phantom stock or incentive plans. And this is, again, it's one of those things that you won't really know what whoever says it means until you read the documents, because it can mean a lot of different things. And if you're a CPA, then you really need to figure out what it is before you try to report it. But in most cases, it's a compensatory bonus plan. And we call it phantom stock because the amount that's paid is tied to the value of the company. So it looks a lot like equity in the actual amounts the employee receives. So you say, the real typical plan is a carve-out plan, which says we'll take 10% of the proceeds of the sale of the company, and we'll take that 10% and we'll allocate what's called 1,000 incentive units to that 10%. And we'll just give people some number of those units, and then they get their percentage of that 10% of the proceeds. So you're waiting for the company to sell, you're taking proceeds from it, and then you're distributing it among a pool of people. So it's just a bonus payment. Again, they're supposed to be employed at the time they get it. But instead of saying, hey, I'm just going to give you $10,000 at this date, I'm going to say I'm going to give you some percentage of the future sale of the company. So if the company value goes up, you get more. And if it goes down, you don't get as much. But it works much like equity, that people sort of participate in that appreciation potentially. It's really flexible. You don't have to do it like I just said. You can make it pay out just like shares of stock. You can say you're going to get whatever a common share gets in this sale of the company. We'll just pay all incentive unit holders the exact same money, whatever the common shares get. You can even include a right to get a dividend payment along the way. Like if you're going to declare some sort of dividend or distribution on the shares, you say, well, this also gives rise to a payment under the bonus plan. So people can have rights that are really similar to holding stock or equity. And the employee, though, doesn't receive any equity. They just get cash on these defined events. So it's common for S corporations who have restrictions on ownership, and common for LLCs that don't typically have, traditional option plans. And like I said before, you typically have to stay with the company to participate. Otherwise, you run into some deferred compensation rules under 409A. And you also might want to consider 280G when you're doing this sort of thing, because you're giving what are probably change of control bonuses, and you could implicate 280G. For those of you who don't know what that is, that's a section of the code that potentially requires the imposition of an excise tax to the recipients of certain individuals that receive bonuses in connection with a change of control of the company that exceed a threshold amount. But if it's an S corp or an LLC, those types of entities aren't subject to 280G. So your typical user of an incentive plan probably isn't under 280G anyway. But if you happen to have a C corp that is not eligible to make an S corp election, have one of these plans, you might be sort of creating a 280G problem in the future. And again, the tax issue is here. There's no long-term capital gains. You're just going to get ordinary income on whatever amounts you receive, because they're just bonuses under a bonus plan. But companies still do them because, like I said, S corps might need to. Other companies just don't. They have qualms about giving out equity. I don't know exactly why. They don't want a lot of shareholders or whatever it is. Or they're all small people that they don't want to really have on their cap table. Maybe they're not accredited investors. I don't really know. Although most cases, an option plan would make it good for securities purposes. I did have, I'll just mention it because I had a recent client who did a really interesting one of these phantom plans. And what they did is, it was a foreign parent with a U.S. sub. And I think the hope in this business is that the foreign parent goes public. And so what the plan they made is that if the foreign parent goes public, then people who have units under the domestic company's incentive plan basically get bonuses equivalent to the value of that foreign parent's public stock price. So if they go public and the shares are worth $5 a share on the public market, each incentive unit under the domestic plan gets $5 per unit. So it's a really interesting animal, but I think it works just like all the other ones, trying to incentivize people based on the value of the company. And I think in that case, they didn't want to give out all the foreign parent stock, I think, to U.S. subsidiary employees. So it was a good fit for them.
I don't know, I had a client, C Corp, venture back, down the street literally, and they had an R&D center in Ukraine, and they wanted to give those guys options, and some of them anyway. And you can't legally give options.
In Ukraine.
You're not a publicly traded company in the Ukraine.
Oh, yeah.
And so we were talking to them, I don't know if they moved forward with it, but a phantom stock type plan in lieu of a straight option to kind of get around those rules. Then those have some interesting issues, though, in the foreign context, options and the phantom stock, as to whether or not those are subject to your cost-plus agreements, and what do you need to do to get the deduction in the local country, and a whole bunch of other stuff.
Right. Well, so was it I was thinking, well, do you have to have the foreign country, have the plan? You could have it in their U.S. plan, right? I mean, U.S. companies could pay foreign service providers for foreign service. I guess they weren't rendering services to the U.S. company. They were probably rendering services.
Employees of the
foreign
country subsidiary.
Yeah.
So it has to be like a back-to-back type arrangement.
Yeah.
I mean, it's unwieldy, but a straight option is just illegal.
Right. Well, yeah, so there's a lot of cases where you can't just do equity, right? And that makes sense. And from a U.S. perspective, I'd say if you had, a foreign service provider, it's sort of a good result to put them in one of these plans because they're rendering services in another country. That's foreign source income to them. So you pay them some amount here, you're not going to be taxed in the U.S. on it. And so it really does come down to the local laws and whether it works in that jurisdiction. But yeah, these can really work for foreign service providers in some cases. Let's see. So I'm going to turn on to stock options now, which probably could be a whole hour in itself, but I'm going to try to cover the highs and lows and the differences between NSOs and ISOs. But a stock option is what we all know. It's a right to purchase stock at a prescribed price, and you typically can only exercise that right once you've vested, although some people will allow early exercise for unvested shares. And then for NSOs, which just means options that are not incentive stock options under the statute, then when you receive a grant of a stock option, you're typically not going to pay any taxes on the grant itself. And that's so long as the option is not in the money. It has to be granted at current fair market value or higher. So the strike price can't be, you can't get an in the money option, or that would be potentially a 409A issue of deferred compensation or just otherwise reportable as income. So people don't pay taxes on the grant, but then when they go and they exercise an NSO, if the shares have appreciated, then they do pay income taxes on that appreciation. If it's now worth $1 a share and it was granted at 50 cents, then you've got to pay taxes at exercise on that 50 cents of appreciation. And you often don't have any cash to do so if you're exercising private company stock. So you don't see a lot of exercises, to be honest. For most private companies, you'd expect optionees to sort of hold the shares and just wait for some liquidity event. But then you're not taking a risk on the shares, and you're not going to be able to get capital gain. So hopefully what they do is they exercise, let's say, not long after they get the shares. There's not a lot of appreciation at that point, or none at all. And then hopefully they hold the shares for at least a year, and then they sell them for capital gain. But what I was just saying, in most cases, is the employees of private companies, they don't want to put money down to exercise. They, maybe they waited and there's some appreciation, so they don't want to pay taxes on that appreciation. So people just hold them, and they don't typically exercise, and then they just get cashed out when they sell. In that case, it's all going to be short-term capital gain or ordinary income, so there's not really a good tax rate in that scenario. But people who can plan into an exercise and hold them long enough, you could end up with a pretty good tax rate on the transaction, but you do have to come forward with some exercise price. If instead the shares are not vested, then you kind of go back to the first topic we discussed, the restricted stock, because some plans will allow you to exercise your option for shares that are not vested. It's called an early exercise. And that just means you're going to buy the shares, but the company, again, has the right to take them back if you leave. So you have to either file the 83B election or not, like we talked about before, and the tax timing depends on whether or not you do file the 83B election. And I'd say stock options are used, commonly for companies that are corporations and have maybe a lot of people that they want to make grants to, not necessarily high percentage grants, but maybe 100 different, or 20 or 30 or 100 different people that all need to receive, some stake in the company, but not necessarily anything over like 0.5% or something like that. So you get them all in one plan that covers securities laws and all sorts of things, and you just give them this right to share in the upside. They don't necessarily have to come out of pocket. There's no taxes due immediately. So there's a lot of things working for it. It's just that you might trade that for ordinary income on the back end. Incentive stock options are under the code, or statutory stock options. And so there's more rules about just how to qualify them. You can only make it a grant of ISOs to an employee. They can't be exercisable for more than 100,000 of stock per year. And that's a sort of a funny rule. A lot of people confuse that with vesting. I mean, the way the rule is actually written is exercisability. So if you had an option grant for 400,000 shares at $1 a share, and it vests over 4 years, and let's say under the plan they're not allowed to early exercise it, meaning they can only exercise vested shares, then that's all going to be an ISO, because each year you multiply 100,000 shares vesting by the dollar strike price, that's $100,000 each year. But if it were early exercisable, you would arguably say, well, $400,000 worth of shares, 400,000 shares multiplied by the $1 strike price is all exercisable now in the first year. And so only 100,000 of those shares would be ISOs, and the other 300,000 shares would be NSOs for tax purposes, even though your grant paperwork says they're all ISOs. So you kind of have to keep track of that a little bit. The stock plans will always say, even though we labeled it an ISO, if the tax rules apply and make it an NSO, then it's an NSO. Just people don't always appreciate that when they're making the grants. And if you have early exercisability, then you have to pay special attention to that rule. Most plans that we do, we don't really allow early exercise. I think maybe this is one of the reasons, and another reason is, people exercise and then they forget to file the 83B elections. So you can run into some issues when you allow early exercise that you just won't have if you don't allow it. Like I said, it has to be to an employee, so that means also that if someone leaves the company, maybe they receive the stock option agreement when they're an employee, but if they're going to leave the company, they have to exercise within 3 months of the time they leave, or it won't be an ISO anymore. And for some odd reason, that's sort of been a broad rule that's been implemented in stock option plans for everyone. Normally, it doesn't distinguish between NSOs and ISOs at all. Everyone just says you have 3 months to exercise after you leave. Period. It doesn't matter whether you have an NSO or ISO. But every once in a while, I'll get a client that says, "I'm leaving this company. I don't want to fork over $100,000 to exercise, and then the stock is worth $1 million, and I don't want to pay taxes on the $900,000 of appreciation, and I only have 3 months to figure this out because I'm leaving." And so in that case, I think, well, if you had just gotten an NSO, and if the plan had been written such that it didn't have this overly restrictive term, you could just hold it for the whole term of the whole 10-year term of the option and decide later. It doesn't matter that you're leaving now, and just have an NSO instead of an ISO. But that's not often the case. That's not often the facts. Every once in a while, you can get the company to agree.
John, is that something that the board could decide to waive? Though they could make a one-off decision or a blanket decision, right?
Yeah. Typically, as long as the plan isn't really narrow. Most plans are pretty broad in the discretion that they give to the board to sort of modify those sorts of terms. And I think as long as you have the discretion in the plan to do that, then you can, for tax purposes, you can just convert it from an ISO to NSO and agree that, hey, you can have the original term of the option no longer than that original term to exercise. And we won't apply this 3-month rule. Just when you get the client, they try to convince the company to do that, and the company doesn't always agree. You might be able to, I think I've seen it a couple of times where the company agrees, okay, yeah, we'll let you hold them longer. You understand it's not an ISO anymore, everyone's okay with that, and then they just hold the option. But a lot of cases, the company will not agree to do that because they don't want to start that sort of policy. They want people to either have to give up their shares, people who are leaving, they want them to give up their shares. They don't want them on the cap table. So they say, no, you gotta figure out how to exercise this within 3 months. And sometimes they can get funding to do that. Sometimes they get a loan. I don't know what it is. There's some third-party financing things that go on.
Just out of curiosity, where did the 3 months come from? Is that statutory?
Well, it is for the ISOs. So it's statutory for the ISOs that if you want to maintain ISO status, you have to exercise within 3 months of your termination. But it's not a requirement of an NSO. So the statutory term ended up in the plan for a blanket for all options. And I think it's probably just company favorable drafting. And so now it's a problem for anyone who might even get an NSO to begin with. They don't even have an ISO, but now they have that same 3-month exercisability term. So it's something to keep track of. And again, for ISOs, so those are the differences in who's eligible to receive them. The differences in taxation is that when you exercise an ISO, for income tax purposes, that appreciation that might be in the value of the stock at that time, meaning the value versus your strike price, that's not income for income tax purposes. And but that doesn't mean you won't pay taxes on exercise of an ISO, and that's because of the way AMT rules work, which are alternative minimum tax rules. So it is income for AMT purposes, and so the benefit of having an ISO is largely gone because of the AMT and the way it applies to most people in the valley. So I don't see a lot of other strong incentives to having an ISO versus an NSO, except for people who might not be in the AMT regime. But common misconception is that I have an ISO, I can exercise it, and I won't have to pay any taxes when I exercise it. But that's just often just not true. And you have to tell people, go talk to your CPA, whatever it is, make sure you're not an AMT. And if you are going to pay taxes. And it could end up being an AMT tax credit that they get, and they hold on to it, and they get it back at some point. But I think that there's a lot of variables in that. You just don't know if that's going to happen. And then the other thing is, ISOs have this. I guess the game is you exercise, and then you hold and sell just for an NSO to get the best rate. You exercise, and you hold and you sell. And for an ISO, the rules to get all of the income to be capital gain for income tax purposes is you have to hold the option for at least 2 years, and then you have to hold it for at least 1 year from exercise. And so you've got sort of this 2-year clock going on whenever you're looking at ISOs. And so theoretically, they get the grant, they wait a year to exercise, and then they wait another year to sell. You will have satisfied both those tests, and all of the income that you have above the strike price, even though there was this intervening exercise income. For income tax purposes, there wasn't any. So all of that income, though, would be capital gain for income tax purposes, assuming you satisfied both those holding period requirements. Also, the other thing I'll mention about ISOs is at the bottom here, where you've got people who have just been holding the options, and that no one's exercised, and they're just holding them, waiting for that sale, which is commonly the case. If they have ISOs, it might benefit them to actually exercise before the transaction. And that's because an exercise of an ISO is not subject to employment taxes. Exercise of an NSO is, but exercise of an ISO is not. And so if they exercise and then they hold the shares, then they just dispose of them in the transaction, they don't pay employment taxes on the proceeds. They might have short-term capital gain, they pay sort of ordinary rates, but they don't pay the employment taxes piece. NSOs, you can't really plan into that because they pay employment taxes on the exercise. And you'd want to have it be substantial, like you want to have them actually exercise maybe a couple days before. You can't have it contingent on the transaction occurring. So you really want to put some meat to it so you don't run into some sort of step transaction argument, or sometimes you even see buyers resist it too because they just think there's risk involved. I think I covered most of this slide already. I've noticed some plans, they now include a notice provision that says, if you're an employee and you sell your shares in a disqualifying disposition, which means you sold them before either that 2 years had lapsed or the 1 year from the time of exercise, then you're required to notify the company of that. And that's because the company wants to get a tax deduction, because they now have a tax deduction because you have disqualifying disposition on ordinary income. So I don't know that anyone actually adheres to that rule, and I haven't really seen it implemented in practice, but that's what most stock plans say nowadays. And again, stock options are really useful for corporations that have a lot of people that need to participate in the equity. Yes?
The exercising of the ISOs and then disposing of them a few days later, getting the short-term capital gain. I'm not super familiar with the net investment income tax, but isn't that sort of, is that essentially a wash on the employment taxes?
I thought the net investment taxes were on top of employment taxes. Is that right? Does anyone else know? Yeah.
I mean, usually they're not gonna both apply, right?
Yeah, they're not gonna both.
Yeah, I don't know that I've looked at it in the light of the net investment tax and whether or not that makes any difference. But I'll think about it. thought they both applied independent of the other.
So
But it then tax,
Go.
the exercise, as you point out, isn't subject to employment taxes, right? And that sets your basis, you know, $10 a share or whatever. If you sell it at 10.50, that piece would be.
That's subject to the net investment tax,
income. So it, you know, all the appreciation from exercise price to fair market value of date of exercise is not subject to NII in the context of an ISO.
Right.
With it, if it's a non-qual, it would be,
Oh, yeah.
because it would be in your Medicare wages.
Okay, interesting. Well, it seems like maybe another reason to have ISOs, potentially.
Yeah,
There's another comment, the disqualifying disposition, I think the bigger companies are pretty vigilant at paying their employees about getting that. I've seen a lot of
Yeah.
clients have to report back. And so the companies have gotten a lot better the last.
Oh, yeah.
last years.
Who do they ask? Do they
Clients
just
ask
ask like current employees, or they ask? I mean, what if people that have
Current
left?
I mean,
Yeah.
and that's why they're getting also very streamlined with, once you exercise, you gotta stay in this account, that we have a relationship with the
Yeah,
custodian that we can obviously get the data from.
right. So someone's really tracking the stock ownership, and they can probably get that information anyway because if you've sold it, you probably had to notify someone to sell it, so they can probably get it from the investment bank or whoever's monitoring the stock. But I haven't heard of the.
I see it more when
Yeah.
a smaller company gets bought up by a bigger one.
Yeah.
The bigger one's very
Oh, okay.
on top of saying, talking to employees about that.
Okay. Cool. Anyone else?
And there's also a withholding requirement in that instance too. It's not just the income tax deduction to the company, but if they're becoming a withholding agent, because if it's a disqualifying disposition, you have to.
Yeah, they have to
all that
withhold for
compensation
employees,
piece
right.
of the-
Yeah, so they need to know if there's been compensation income element to that
Exactly.
ISO, and then they might have to withhold from their wages, right? Yeah. So you're right. They need that information. All right. So the next topic I'm going to talk about is revenue sharing. It's let's check up here. Time, okay. This is something you don't see a lot with employees. I'd say more often with contractors and other types of service providers. But basically, they're just agreeing in their services terms, and their rate of compensation is tied to some sort of revenue of the company. So this is, it's an alternative to equity because you're not giving them equity, but you're giving them, payment that is tied to how much money the company is making. So it's just something that might be appropriate in certain circumstances that people don't always consider, but they might skip over. They say, well, do I want to give this consultant some equity in the company? And you think, well, maybe I don't, and I don't know how long this relationship's going to last, or whatever it is. You might instead just agree, well, yeah, I'm going to pay you some flat fee, but I'm also going to give you some percentage of our revenues that we generate from your business or what you're doing, and we'll pay you that way. So you're getting some upside too, and you're getting something out of what's occurring at the company. And so the service provider's incentivized sufficiently, and you don't actually have to give out equity for tax purposes. It's compensation income for the service provider. There's no opportunity for capital gain because it's really just a compensatory payment. And then the last but not least topic for equity compensation that I have on my list anyway is profits interest. Art touched on this topic a little bit in his talk, but they can be used in partnership type entities. So you have LLCs that are taxed as partnerships and LPs and other partnerships. But essentially what you're agreeing to do is give someone, or you're giving someone a right to share in the future value of the company, not the current value. So if the company's worth $10 million now, you're going to give them a profits interest that says you share in the growth above $10 million, not this first $10 million. And we do that in a partnership because That way they don't pay taxes on the current grant. You could certainly give them a grant that has them share in both aspects, the current value and the future value, but they're going to have to pay taxes on that current value if you do that. And so in a partnership, you have this flexibility to really bifurcate things, and it really depends on careful drafting of the LLC operating agreement and the various contracts involved, but you can agree to give them something that, is just future gain. And you do it because, let's say in this partnership, it's a relatively large, percentage stakeholder coming in. The service provider must be somewhat valuable, so they're getting a pretty good stake in the company. If it was a really small percentage, I don't know that I would go to the trouble of doing profits interest. I might do something like a phantom plan instead. But, if you have someone who's getting a significant stake and the value is somewhat significant, because again, if the value is low, you just give them a capital interest and they pay taxes on, like next to nothing because it's just not valuable. But if the value is significant and you're giving away a significant piece, then you probably want to consider a profits interest because they won't pay taxes on it immediately, and it has much of the upside. It won't have that initial, whatever the current value of the company is, it won't have that. But in most cases, companies aren't mature enough that there still is a lot of upside, and this person can then participate in that growth. It works, much like a stock option. When you give someone an option, they get the current fair market value exercise price, so they don't get the current value anyway. And so this is a little bit similar in concept, that they only get the increase. And I think that Art said he always files an 83B election unless you don't have to. I think I'd file an 83B election if the profits interest were restricted, meaning they might have to give them back. I think there's a revenue ruling that actually says you don't have to, but I'd just do it anyway, just in case. So you file it, and then the way you could do profits interest also varies too. So you could say, well, you're going to only share in some percentage of the proceeds of the future sale of the company, or you're only going to share in operating income but not a future sale, or you'll share in both. Maybe you're going to share in the operating income plus the future sale income. And it really comes down to however you want to do it. I've seen a lot of people, they don't really want to make K1 allocations every year to all the profits interest holders, so they give them an interest that is really only in the future sale of the company, not in the operating profit. So that way you might have to put them on the K1, but you don't allocate any income to them. You don't have to make tax distributions. It's a little simpler to have them just share in the future sales proceeds versus everything. But if you really want them to be more like an equity holder or other equity holders, then you have them share in everything. They'll get a K1 just like other partners and probably get an allocation of income each year. The way I've been drafting these, and I think it's probably the better way that I've seen, is we end up defining like a threshold amount every time grants are made. So you figure out what the value of the company is each time you make a grant, and then that determines what your threshold is. And the way the threshold works is in the operating agreement, it will effectively bar distributions to the group of people that have a threshold amount, at or above that number, because they only participate in distributions that have occurred after the date of their grant that have occurred in excess of that threshold amount. So if the threshold amount is 10 million, someone gets a grant and that's their threshold, then you say, well, yeah, we've got a lot of operating income, but every year, you haven't participated yet because we haven't distributed $10 million yet. Once you've distributed $10 million, you pass that threshold, now you get to participate based on your percentage. So that's the way I've typically been drafting it.
Is it a cumulative threshold or a per year type?
It's cumulative because, you might
It's like
distribute.
a hurdle rate.
Yeah, it's like a hurdle. Once you get above it, then you participate. And again, it has to only consider the distributions from the date of the grant, so you're not really looking at the whole life of the partnership. And it could be different for different people, so it's probably a pretty complicated analysis of whether or not someone actually participates in the distribution, because you have to look at when they received their grant, their threshold, what has been distributed since then. It's complicated, certainly. And so that's why I think you'd probably only use it for more significant stakeholders. But again, and then if there's not a lot of operating income, let's just say it's a company that's growing a lot, there's not a lot of operating distributions or income, but then they are eventually sold, they could get long-term capital gain on the sale. I think Art said under the revenue rulings, you probably want to have it occur more than 2 years after the grant, that sale. So I would be a little worried about granting profits interest, somewhat close to a transaction that you see. But if it's early on, you would just grant them and hope that nothing really happens for a couple of years, and then they sell and they get a long-term capital gain in the sale, just like other equity holders. So that's, let me think. I'll mention one other type of profits interest too. Sometimes you can do one that has the goal of making them like a capital interest. So, again, let's, in that scenario where someone doesn't participate in the first $10 million because that's the current value, you could craft your allocation provisions to actually allocate more income to the profits interest holders until their capital account is their pro rata capital account of sort of the total. So you can get them to a spot by allocating more income to them to really make them equivalent eventually with the other equity holders who do participate. I mean, you actually have to have income for that to happen, so there's some things that have to play out. But theoretically, you could work someone in from like a zero capital account, sort of work them up to their percentage capital account of the whole, and then they'd be much like an equity holder and then participate just like any other equity holder. So there's different ways to do it, and depending on what your clients want to do, it can often be used as a good solution. And again, it's only for LLCs and partnerships, but a lot of our clients are small, and so we do this quite a bit. All right, I've got, unless there's questions, I've got a couple examples.
Going back to your RSU questions,
Yeah.
If I have an S corporations, will the allocate profit or loss based on the percentage you give them at grant or based on the vesting if they do 83B elections?
We're talking about RSUs or restricted stock? Well, RSUs, again, those are just a bonus of stock, right? So.
But it's vested by 4 years that the employee take the 83B elections.
So you can't do an 83B election for an RSU because you don't have any actual property. You're only going to get each piece of that. Let's say it's vesting over 5 years. What that means is you get stock each time over, let's say annually over 5 years. You get 10 shares now, 10 shares a year from now, 10 shares. Each time you get shares, those are vested shares. So there's no restricted property actually involved. So there's no 83B applicability to an RSU. Unless for some reason they're getting a grant of stock that is not vested. I mean, I guess you could have an RSU for
An
unvested
RSU,
shares.
it might be something else that,
Yeah.
say 4-year vesting,
Mhm.
but that he pay upfront everything because he did the 83B elections.
Okay. Well, I think he's got actual restricted stock then, probably.
And so for S corporation, do you allocate the whole share at the time of granted or at vesting?
I want to say that you would. I'd have to check the S corp rules.
So once
Yeah.
you get hold of stock, which is the property, then you can make a redemption. So if a company, have a vesting period of 4 years, and they give you a stock right away,
Yeah.
then you can actually make a redemption.
Right. I think that's what she's saying. I think that they got the stock right away. It's just vesting over 5 years. So yeah, I mean, you would make the 83B election, but whether or not you share in the S corp earnings, I think the normal rule under S corps is that you look at a per day, per ownership allocation. So you would say, well, this is the day you got your shares, and so you were allocated income, from that day forward, sort of. But I don't know if it's unvested whether that changes it, or in some cases when it's. Go ahead.
On this one, yeah, you do, if it's restricted stock, you do start allocating it.
Okay.
Onto the 83B, but it gets really weird if they forfeit it.
Because I'm afraid of the two types of stock. If you have one restricted, one non-restricted, is that going to be like two?
Oh, two classes of
two
stock.
classes of stock?
I don't think so. I don't think, as long as they share in the same rights to sort of liquidation, that sort of thing, the economics are the same. Yeah, as long as the economics are the same between the shares, I don't think the fact that some is restricted and some is not will violate the second class of stock rules. I'm pretty sure it doesn't, actually.
Explicitly, it isn't in the regs, they do allow the allocations, so.
Yeah. Did you have a question?
I think what they may be trying to get at is more of a clawback on stock, which is a restriction, but.
Right.
It's personally, rather than trying to get the cake and eat it too.
Yeah.
But it leaves us tax people.
Yeah, so Yeah, I think you're right.
Employee tried to argue that, oh, your profits only at vesting. The employee said no, because I bought it, I should be
Yeah.
right away. My allocation should be at right away.
Yeah.
I was like, I'm not really sure which one is correct.
Yeah, it's interesting. I think it's probably right away. You know, a lot of S corp owners have extra issues to consider when they're doing equity grants because it's not just like future shares of proceeds. It's the current earnings of the company year over year. Once someone's a stockholder in S corp, because there's no, you can't have a second class of stock. Those people have to get allocations. They're probably going to be entitled to distributions. So, I mean, for S corp owners, you really have to consider whether you want to give out equity or not. It sounds like in this case, the S corp owner might not have fully understood what he was giving away, and so it's.
His lawyer said what he did is okay.
Yeah.
I say no, if they are to invest it right up front, that's when you're entitled to the whole thing.
Yeah.
He said no, my lawyer said otherwise.
Said it's different. I don't know. I mean, I'd research it, but I kind of think that you have to allocate as though there is no restriction, and that so then he gets essentially what any other owner would get. I'd have to look to confirm though. Any other questions? I'm just going to have a couple of examples since I have a few more minutes. Let me confirm that I do. I have a couple more minutes, so I'll just do a couple of examples that, you're going to guess what type of equity I should give this person based on the facts. Let's see if anyone participates. So let's say you have an S corporation and they want to incentivize a foreign service provider, and they believe there is an exit on the horizon, but it is an S corporation. So what do you think they might do to incentivize this foreign service provider?
Phantom.
Yeah, that's right. Phantom, exactly. You do phantom or incentive plan because you can't have them as a shareholder. You got the S corp rules, and you see an exit on the horizon, so you have a perfect opportunity to say, hey, I'm just going to give you some percentage of that sale under a phantom plan. All right, the next one is you've got a startup with very low value stock, and you need to hire an executive who's going to command sort of a significant percentage of the company, and you want him to be subject to vesting, but he's probably going to be more than 5%, and it's a corporation. And again, the value is quite low right now. What would you probably recommend there? Yeah, that's right, restricted stock. So, you give them the stock subject to that forfeiture, and they file an 83B election because the value is low. They don't pay much taxes on it, and they get the potential for long-term capital gain. Because they're a significant holder, you probably wouldn't just give them a stock option, which you could do also for, lower percentages, but you'd probably be tax sensitive and give them restricted stock. Okay, the last example, you've got an LLC with significant value, and you've got a significant new owner coming in, and you want to incentivize that person in a tax efficient manner. Anyone know that one? Yeah, profits interest. I'm sorry, yeah, profits interest. All these terms are so similar. I had to read it again in my mind. You give them a profits interest because, the LLC has value right now. You can't really just give them a capital interest unless they're going to pay taxes on it. And they're so significant of an owner that you probably want to do something a little more tax advantageous than a phantom grant, which you'd probably do for a smaller owner. All right, that's sort of all I have, unless there's any additional questions. Okay. Cool, thank you.